We begin this hour with breaking news. Mark Meadows, criminal defendant Mark Meadows, co-defendant of Donald Trump in Georgia, has just filed an appeal with the 11th Circuit Court of Appeals asking for a hearing by the full Court of Appeals. His first appeal in that case was heard by a three-judge panel who rejected Mark Meadows' attempt to move his case to federal court. He's currently being prosecuted in Georgia, in Fulton County, Georgia. He wanted that case removed to federal court. A three-judge panel unanimously ruled against him. He is now asking to appeal to the full 11th Circuit. That would be 12 judges who would then hear that case. That could then lead to him appealing to the United States Supreme Court on this. That is breaking just within the last few minutes. Mark Meadows asking for a hearing of his appeal by the full 11th Circuit, all 12 judges, after being rejected by a three-judge panel. Three-judge panel is the normal way federal appeals are handled. It is unusual to try to reach beyond them, although it does happen. We will hear from our legal experts about that breaking news. 2024 is, of course, a presidential election year, but it is also the year of Defendant Trump. Defendant Trump 2024. And the first big action of 2024 for Defendant Trump is next Tuesday, when the Federal Court of Appeals in Washington, D.C., a three-judge panel, will hear oral arguments in the case of United States of America versus Donald J. Trump, in which Donald Trump is charged with federal crimes leading up to and on January 6th. The first defense Donald Trump has offered to those crimes is that he is immune from criminal prosecution because he was president of the United States. If that argument holds, then all four current criminal prosecutions of Donald Trump will collapse. The appeals court has set an expedited schedule for Donald Trump's appeal of trial judge Tanya Chutkin's ruling that there is no form of immunity that protects a president from criminal prosecution after he has left office. Today, the appeals court issued a notice to Donald Trump's lawyers and Special Prosecutor Jack Smith that the lawyers for each side should be prepared for questions next week in oral argument by the judges about amicus briefs filed in the case by third parties, including one that says Donald Trump has no right to appeal Judge Chutkin's denial of immunity until after the trial. So it is possible that Donald Trump's appeal of this absolute immunity claim could be short-circuited by the appeals court if they agree with that amicus brief, which they find important enough to have warned the lawyers that they are going to discuss it in oral argument next Tuesday. Here is the immunity claim that Donald Trump's lawyers have made in their written brief to the appeals court. No president, current or former, may be criminally prosecuted for his official acts unless he is first impeached and convicted by the Senate. That claim defies the history of impeachment, as it has been used against federal judges, for example, who have been criminally prosecuted before being impeached. Donald Trump's lawyers seem to know that they will probably lose that claim of immunity with the appeals court, and so they have added another layer to their claim of immunity from criminal prosecution for Donald Trump. Quote, "Nor may a president face criminal prosecution based on conduct for which he was acquitted by the U.S. Senate." And that claim, of course, applies only to Donald Trump, who is the only president ever to face criminal prosecution after being acquitted on similar charges in an impeachment trial in the Senate. Of course, Trump lawyers are not quoting the Constitution when they make that claim. They are simply inventing a principle that they hope a Trump-friendly Supreme Court can accept. Special Prosecutor Jack Smith's 82-page brief to the appeals court describes what is at stake this way. The defendant's sweeping immunity claim threatens to license presidents to commit crimes to remain in office. The founders did not intend and would never have countenanced such a result. Jack Smith says that if the appeals court accepts the Trump argument, then that would give immunity to, quote, a president who accepts a bribe in exchange for directing a lucrative government contract to the payer, a president who instructs the FBI director to plant incriminating evidence on a political enemy, a president who orders the National Guard to murder his most prominent critics, or a president who sells nuclear secrets to a foreign adversary. Because in each of these scenarios, the president could assert that he was simply executing the laws or communicating with the Department of Justice or discharging his powers as commander-in-chief or engaging in foreign diplomacy. Under the defendant's framework, the nation would have no recourse to deter a president from inciting his supporters during a State of the Union address to kill opposing lawmakers, thereby hamstringing any impeachment proceeding to ensure that he remains in office unlawfully. As usual in federal courts, the oral arguments of this appeal will not be televised next Tuesday, but an audio feed will be available, which I hope will be carried live on this network. Leading off our discussion tonight is Joyce Vance, former U.S. attorney and professor at the University of Alabama School of Law. She is an MSNBC legal analyst and co-host of the podcast hashtag Sisters in Law. Also with us, Harry Litman, former U.S. attorney and former deputy assistant attorney general. He is a senior legal affairs columnist for the Los Angeles Times. And Joyce, let me just begin with you on the breaking news of the night. You know a great deal about the workings of the 11th Circuit Court of Appeals. Mark Meadows petitioning the 11th Circuit for what they call an en banc rehearing, which means all of the judges on the bench, all of the 11th Circuit would hear the case, not just the panel of three. How common is it to be able to get the full appeals court to hear one of these appeals after a three-judge panel has rejected it?
Yeah, you know, it's very uncommon. The 11th Circuit argues relatively few cases compared to many of the other circuits to begin with. En banc usually happens in this circuit in 2 weeks, where just a handful of cases will be set each year for oral argument in the spring and again in the fall. So I suppose from Meadows' point of view, it's advantageous. There would certainly be delay involved, but the judges on the court will be actively communicating with each other to decide if this is the sort of issue of magnitude that warrants one of these very rare en banc settings. I think it's unlikely, particularly with a 3-0 decision authored by the chief judge on the circuit, Bill Pryor, that there will be much movement to take this one to en banc.
And Joyce, if it doesn't go to the full appeals court, does Mark Meadows then try to go to the Supreme Court?
I think he does. He's brought on new lawyers today, experienced Supreme Court practitioners, and, you know, TikTok, if en banc is denied, then his time to appeal for cert is running.
Harry Litman, I know you have surveyed the amicus briefs, the briefs filed in addition to the briefs filed by the parties in this very important appeals court hearing next week in Washington, D.C. And today the court said, we want to hear from both sides about these amicus briefs. The one that has the most vivid piece that does not appear in Jack Smith's pleadings is the amicus brief saying the appeals court doesn't even have jurisdiction over this question at this stage. What is your assessment of what we see in these amicus briefs and the pieces of them that the appeals court will be most interested in?
Yeah, and there are now 4. We've just and they run the gamut from reinforcing the arguments with very eminent parties to now there's a new one that actually says Jack Smith is an unconstitutional officer in the first place. But Lawrence, I think the one you mentioned really bears watching. What it says is that the test for whether or not he should have been able to take an appeal in the first place was really changed by a unanimous 1989 opinion from the Supreme Court that really narrowed the circumstances when you get that interlocutory appeal. And I think they will press the parties on it, and if that claim holds up, it means the whole thing goes back to Chutkan and the clock now recommences. So that would be the sort of best scenario as far as delay goes. A very quick point about Barb's Meadows point. He's now hired, has Meadows, probably the consensus, top or one of the top 3 lawyers in the country, Paul Clement, former Solicitor General, extremely well respected in the Supreme Court in particular. So it both is telegraphing delay, but also he continues, in general, Meadows has always had the most impressive set of lawyers, and Paul Clement is a name that's sort of eye-popping in the Supreme Court.
So one of the issues that the Trump lawyers are raising is this constitutional principle that they have invented, that a president who has been acquitted by the Senate in an impeachment trial cannot be charged with crimes having anything to do with that impeachment trial. Let's listen to Mitch McConnell's opinion of that.
President Trump is still liable for everything he did while he was in office as an ordinary citizen. Unless the statute of limitations is run, still liable for everything he did while he's in office. Didn't get away with anything yet. We have a criminal justice system in this country. We have civil litigation. And former presidents are not immune from being accountable by either one.
And Joyce, that has always been the understanding of the United States Senate and everyone in Washington government during our lifetimes. President Nixon accepted a pardon after resigning the presidency from his successor, President Jerry Ford, because he was afraid that he could be prosecuted for the crimes that he committed while president.
Yeah, that's exactly right. And we see Mitch McConnell literally taking the principle for granted when he speaks from the floor of the Senate. And that's because of separation of powers in this country. 3 branches, each with its own distinct responsibilities and rights. Impeachment is something that happens in the legislative branch. Prosecution happens in the executive branch. And Jack Smith has made this argument powerfully before the Court of Appeals. I heard Harry say earlier that he was absolutely confident that this argument is a loser, and I want to adopt his view here. It is absolutely a stone-cold loser.
And on that absolute confidence of Joyce Vance and Harry Lippman, I want to thank you both very much for starting our conversations tonight.
Thanks,
very
guys.
much appreciate it. And coming up tonight, Donald Trump's lawyers went to court in Maine to try to get his name on the presidential ballot there after the Secretary of State relied on the 14th Amendment to bar Donald Trump from the ballot in Maine. Harvard Law professor Lawrence Tribe joins us next. Bruce Hepler is now Donald Trump's helper in a new lawsuit. Turned the decision by Maine Secretary of State Shenna Bellows to bar Donald Trump from the presidential ballot in the state of Maine. Bruce Hepler made legal history in the state of Maine tonight by being the first attorney in Maine's history to file a lawsuit to get the name of a former president of the United States restored to the next presidential ballot offered to Maine voters. The Trump legal filing says, quote, the secretary had no statutory authority to consider the challenges raised under Section 3 of the 14th Amendment. Section 3 of the 14th Amendment, as many of you know by now, says that any officer of the government who has engaged in insurrection is disqualified from holding office again. Page 8 of Donald Trump's Maine lawsuit filed tonight says President Trump did not engage in insurrection. And it says Section 3 of the 14th Amendment bars persons otherwise subjected to its disqualification from holding specified offices, not from running for them or from being elected to them. The simple 9-page lawsuit asks that the court, quote, require the secretary to immediately place President Trump on the Republican presidential primary ballot. Secretary of State Bellows appeared on this program on Thursday, shortly after issuing her 34-page decision that Donald Trump could not appear on the Maine ballot because he engaged in insurrection.
Mr. Trump was aware of the tinder laid by a multi-month effort to delegitimize a Democratic election, the election of 2020, and then chose to light a match on January 6th, and then did nothing for a time. The evidence presented demonstrated, and remember, the events of January 6, 2021, and this was borne out by the evidence, were unprecedented and tragic. They were an attack not only upon the Capitol and on the government officials there, members of Congress, former vice president, but also an attack on the rule of law. And the evidence demonstrated that they occurred at the behest of and with the knowledge and support of the outgoing president.
Joining us now is Professor Lawrence Tribe, who has taught constitutional law at Harvard Law School for 5 decades. His new Boston Globe op-ed is titled "In Defense of Maine Secretary of State Shenna Bellows' Courageous Decision to Keep Trump Off the Ballot." Professor Tribe, I read your Globe op-ed piece. I want to go to the new information we have tonight in Donald Trump's legal filing in Maine. Point one is he did not engage in insurrection. Those words are in quotation marks, engage and insurrection, leaning heavily on whatever the legal definition of engage and insurrection turns out to be in this case.
Well, that's exactly what we would expect him to say, but there's nothing new about that. Shenna Bellows held a hearing in which she considered all of the legal materials relevant and all of the factual evidence, including the evidence developed at the January 6th congressional hearings in which Donald Trump was invited to appear. He was given ample opportunity to present his side of the narrative in this administrative hearing. He didn't succeed. His claim that he was denied fair process is based on nothing in the law. He's absolutely confusing an administrative hearing of the kind that Shenna Bellows properly held under the law of the state of Maine with a criminal trial or with a civil trial in which damages might be assessed or the property or liberty of the defendant might be at stake. Here, what is at stake is whether Donald Trump disqualified himself. Unlike many other possible disqualifications, like age or birth in the United States, where there's nothing an individual can do to remove the disqualification, it's just there because of a fact that's beyond that person's control. Here, it's entirely within the control of an officer of the United States who takes an oath to support the Constitution, not to engage in insurrection against it. If he chooses to engage in insurrection, there's nothing undemocratic or unfair about saying he's disqualified himself. The 34-page opinion by Secretary Bellows is very precise. She invokes the right statutes under the law of Maine, and there's nothing in what the president's new lawyer just filed that in any way gives the courts of Maine a basis to overturn what she did. But she was right in suspending the effect of her decision pending an appeal to the Superior Court of Maine, recognizing that she doesn't have unilateral authority to make this decision.
Donald Trump's new Maine lawyer is leaning on the statutes in Maine, saying that those statutes only give the Secretary of State authority to do things like make sure he has enough signatures to be on the ballot, requires thousands of signatures, make sure his address is correct, kind of clerical things like that in his application to be on the ballot. And then the Trump lawyer says the Secretary had no statutory authority to consider the challenges raised under Section 3 of the 14th Amendment.
Well, they're basically trying to treat the disqualification clause of Section 3, which is really central to the preservation of democracy from those who would overturn it, as a kind of second-class status, not nearly as basic as residency or birth. It isn't. It's equally important. It's perhaps the most important qualification. And there's nothing in the law, either state or federal, that draws a distinction between bases of disqualification that are rather simple to apply, like age, and those that are more complicated to apply, like whether you're an insurrectionist. There's no principled basis for treating them differently, unless we say that hard questions are not to be put by the Constitution of the United States to public officials. What it all comes down to, all of these arguments, both here and in Colorado, are not really arguments about Section 3 of the 14th Amendment and why conservatives and liberals alike have concluded that it applies here. They're basically arguments against the Constitution. They're arguments that say the Constitution of the United States made a big mistake in telling officials of the United States, especially a president, that if they take an oath to support the Constitution and then turn against it and engage in treachery against the Constitution, insurrection against it, then they can't run again. That provision just shouldn't have been there, because it's not a good idea. If somebody is popular enough to potentially win, then they really ought to be able to run, even if they're disqualified. There's no basis for that. It's like somebody saying, I don't like the Second Amendment. The Second Amendment means a lot of people die who shouldn't die, so I'm going to disregard it. You can't just take part of the Constitution and say you don't want to take it seriously. Either the Constitution is the law of the land, and it's the only fundamental law we've got, or it isn't. And in a year like this, when the future of democracy around the world and the future of the rule of law is basically up for grabs, to take that position, and certainly Donald Trump takes it when he says he's absolutely immune from prosecution for anything that he does as president, like even if he took a bribe in order to veto a bill, because that's his job, he can't be prosecuted. That is a formula for ripping our democracy apart. That's what's at stake in this new year, 2024. And we have to recognize that that is the issue before us. In this appeal in Maine, and in the appeal he's filing from Colorado, and in the claim of being above the law that he is making when he claims immunity. In fact, in those immunity cases, he makes the remarkable argument that he's more like a king than he is an officer of the United States. Some of his defenders say he's not an officer under the United States. He is the government of the United States. L'État est moi. I am the state. That is not the way the government works that most of us would feel safe living in.
Harvard Law Professor Lawrence Tribe, thank you very much, as always, for joining us tonight.
Thank you, Lawrence.
Thank you. And from one distinguished professor to another, coming up, Donald Trump might have to go to the United States Supreme Court to get his name on the presidential ballot in Maine and Colorado, which would leave Supreme Court justices once again playing amateur historians, this time about the 14th Amendment. For the guidance of a professional historian, the Supreme Court should consult the work of our next guest, Yale history professor David Blight, an expert on the 14th Amendment. Professor Blight joins us next. Sometimes the brilliant guests on this program are just getting warmed up when we have to go to a commercial. Such are the perils of commercial television, of course. That happened Thursday night when Yale historian David Blight was explaining to us the history, the detailed history of the 14th Amendment and how it has become the legal basis for banning Donald Trump from the presidential ballot in some states.
The text is clear here. Make no mistake, and many constitutional lawyers have argued this. It's the politics that, of course, is not clear. And we could end up with, and I've read the decision by the Secretary of State in Maine, and on at least two of the three lawsuits. The third one didn't make much sense. She's dead right on the text of the law. Now, the other thing people should understand is that Section 3 of the 14th about anyone engaging in insurrection is part of an omnibus bill. It's a great omnibus bill that was debated for months in 1866 on the floor of Congress. It was about birthright citizenship, equality before law, the right to vote, although that was couched in cutting a state's representation if they denied the right to vote. Then it was about this barring people from holding office who engaged in insurrection. And the fourth part was all about denying Confederate debt. The federal government was saying, we're not going to pay those states' debts. All of those bills were complex and complicated, and they put them all together for a very large single purpose. And that's what's going on right now in an unprecedented way. It was to make sure that the Confederacy was once and for all dead, and that it could not ever exist again. That is, that somebody could try to take some states out of the Union over racial slavery or over anything else. And that's what people need to understand here. Section 3 wasn't just some politicized moment that can now be used in some politicized way. It was part of a very large effort by the original Republican Party to put the Union back together in such a way as to try with their laws. As John Bingham, the author of Section 1 of the 14th Amendment, put it, he says, you have to put them in terror of your laws. They're trying to use law to put a union back together, to reinvent a United States and make sure that that insurrection could never happen again. And what do we have now? We have a January 6th insurrection. We have a second lost cause. The Trumpian lost cause could win the presidency again and come back into power unless we use the terror of our laws to prevent it.
Joining us once again is David Blight, professor of American history and African American studies at Yale University. Professor Blight, thank you very much for coming back. And I just can't tell you how agonizing it is for me when I have to go to a commercial in situations like that, as we did the other night. And I just wanted to give you a chance to more time to expand on your point, with a departure point tonight being what we found in Donald Trump's new legal filing in Maine, where one of the points that his Maine lawyer makes is the 14th Amendment bars someone who engaged in insurrection or gave aid and comfort to insurrectionists from holding office. And the legal filing says it does not bar them from running for office, and it does not bar them from being elected to office. It just bars them from holding office. What do you make of that distinction?
Well, it's word salad. It's nonsense. It's a misreading of Section 3 of the 14th Amendment, without a doubt. You mentioned earlier when you were talking to Professor Tribe that the Supreme Court ought to be, doing its homework or something. So why not? Let's give them some homework. They obviously, or their clerks, I hope, are reading all the great debates of the winter and spring 1866, when the 14th Amendment was debated. Incredible debates. These were men reinventing a constitution and fighting like hell over it. But they also could just start by reading Chapter 2 of Eric Foner's great book called The Second Founding. It's called Toward Equality. It's a single chapter on how did these parts of the 14th Amendment come about. They could read that in 20 minutes, and then they can go spend hours on the great debates of 1866. And they should especially look for the speeches by John Bingham. It was Bingham who voiced that quote I used the other day, put them in terror of their laws. That was Bingham. And by the way, Bingham was an anti-slavery, genuine abolitionist Republican from eastern Ohio, almost over to Pittsburgh. He never made it into the Senate or ran for the presidency, but he's one of the great unsung heroes of American history. He authored Section 1, and he had a lot to do with authoring Section 3 of the 14th Amendment. And if you're giving me a little time on Section 3 again, the key thing to know here, and first of all, I have to say, as a historian of Reconstruction, there are lots of us who study this, and I'm by no means the only so-called expert. But it's like Section 3 has arisen from the dead. It was just gone. Nobody ever cared about it. Nobody ever read it. Now, every time I turn on the news, I read the paper. I'm seeing the full text of it. Thank God for this constitutional education. But again, that came out of, first, what was known as the Joint Committee on Reconstruction. This was a group of 15 members of Congress brought together in the winter of 1866 to assess, okay, what has this Civil War wrought, and what should we do about Reconstruction? And that led to the debates of how to fashion an amendment in various parts that would begin to put the Union back together and define just who these freed African-American people were, and how the answers to that were going to redefine what the United States was. That joint committee saw 144 witnesses, including Robert E. Lee himself, and they came up with conclusions that used language like, quote, the conquered rebels and traitors should not participate in making the laws for the conquerors. Now, we're not in that situation. We haven't just had a civil war. But we are in a situation where one side wants to run a man for president who, according to the Secretary of State of Maine and many, many, many other indictments of him, fashioned, organized, and abetted an insurrection against the functioning of the U.S. government and tried to stay in office. Now, if indeed his lawyers can win in court on the definition of Section 3 of the 14th Amendment, then it's as if we're going back and erasing the very reason it was put there in the first place, which to the radical Republicans who wrote it, the original Republicans in 1866, they were trying to prevent a new slave power, a new organized attempt to create a slave-holding republic. They were trying to prevent a new confederacy of some kind that would come out of the South if they were not afraid of the law. And above all, what John Bingham wanted out of this 14th Amendment, and this is what he called it, he said he wanted to federalize the Bill of Rights. And most Americans don't fully grasp, I think, just what that meant then. That meant turning federalism on its head. That meant placing the federal law in the states by federal power. And that Section 3 is at the heart of that idea. It said if you broke your oath and you left the Union and you rebelled against your government, you will never hold office again. And I was also struck at how the Secretary Bellows up in Maine stressed the word oath. She said, I'm just following my own oath. I've got to follow my oath. Well, Oaths are at the heart of this. If you violated it and you left, you can't hold that office again. And that is exactly what Donald Trump did.
Professor David Blight, we are up against the dreaded commercial again. Thank you very much for joining us tonight. Thank you for giving us our reading assignments about 1866. We will do it before our next class reconvenes here. Thank you very much, Professor.